All right, we want to turn back now to the Idaho student murders case going on in Idaho. Bryan Kohberger is accused of killing 4 University of Idaho students in November of 2022. Right now, a hearing is underway as the defense argues that they should be allowed to survey the jury pool in support of their motion for a change of venue. So let's get you back into court now.
He can have a fair trial. I think the court should not have issued an order stopping us, but set a hearing. Shorten time, set it for Monday morning if the court wanted to set a hearing for that Monday morning. We wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been more damage. I mean, you know, this less than 2 weeks really has very, very little impact, okay, on your work.
It does have an impact, Your Honor.
You don't even have a trial set. Come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem, what sets me back, is getting my work complete to get my briefing to the state in the time and the deadline that I was already given and meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here, okay, if there was some communication between you and the state about the survey.
There are things I can communicate with the state about, and there are things that I cannot communicate with the state about. How I'm preparing my case is not one of those things. It's just not one of those things. I go and see Bill and Ashley. I go to their office every week. Oftentimes we talk. We email each other. We talk to each other. But I don't need their permission every step of the way to prepare my case. Doing these surveys is not an anomaly. This is something that's done in these high-profile cases.
Well, apparently, Mr. Alden did not even see the non-dissemination order, and you apparently did not give that to him. So this is a very not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people, without a permission of the court, without discussion with the state. I mean, that's troubles me. And then when I'm being accused, directly accused, okay, by you in your brief, that I violated his due process rights. Now, that's not what the law says, and that's not what the facts are. And you even cited cases that say exactly what due process is in the law, right?
I understand that, and I agree that's what due process is. My issue is that the order was signed, stopping our work without a chance to be heard. It's as if the state and the court had decided we violated the non-dissemination order, and we didn't.
All I was doing was stalling it, okay, for less than 2 weeks so we could have this hearing, number one. Now, if you feel like you've been prejudiced or your client has been prejudiced for less than 2 weeks, okay, in this work, I'll push it out. I'll just push out the trial. I mean, not the trial, but the hearing. I mean, is that satisfactory?
Your Honor, I think that might be what we need.
Fine.
I need to figure out if we're going to be able to continue the surveys. But if we are, I expect that we will need some additional time to get them done so that I can get the work to the state to review.
Okay, well, that's a different issue. I've never said, no, you can't do a survey. This was a total shock to me that Friday at 4:30.
I can understand that. It was a shock to the state.
I had to stall it out, okay? Because so that we could all talk about it and figure out what is the right path, okay? Because this is a big deal. and I take it very, very seriously. And I was surprised, okay, that this was happening behind our backs, my backs. Okay?
I understand that this probably is the first time this court has run into it. I know it was the first time that Mr. Thompson has run into it. I haven't used the survey in my own cases because I haven't had a case like Bryan's case before. This is an extremely high-profile case. I've been involved in a lot of capital cases, and I understand the standard of care in capital cases. I also know that this very kind of survey was used about 7 years ago in Kootenai County in another high-profile case. I wasn't on the case, but I'm aware of it. I'm aware that this very survey has been used in other jurisdictions, other counties in Idaho and other states in really high-profile cases. So I understand that it was a surprise to Mr. Thompson. He told me it was. And I'm hearing the court say that's a surprise as well.
It's how it was done. I'm not concerned. I figured there was going to be a survey at some point. There would have to be. It was the way it was done, okay, and the questions that were asked. That is.
All right, folks, we do need to pause testimony right now, and I want to take a break to bring you an update on the Georgia election interference case. Today, the judge denied a motion by the attorneys for former President Donald Trump to dismiss the indictment against him. Now, the indictment accuses Trump and 18 others of participating in subversive actions in order to overturn the 2020 presidential election in Georgia after President Joe Biden narrowly defeated Trump. Now, Trump's attorneys claim political speech by the former president is protected under the First Amendment, but the state argued that Trump's speech was part of a conspiracy to commit crimes and therefore not protected. Well, the judge ruled that the charges do not suggest Trump and others are being prosecuted simply for making false statements, but because they acted willfully to harm the government. The judge did leave the door open for the defense to raise their challenges again later. All right, we're going to take that break now. We're going to get you back to more arguments in the Idaho student murders case when we come back. Keep it here on Court TV.
Court TV fans, you demanded it.
Here we go, do it.
So now you're getting more true crime at nighttime.
Oh my God, oh my God.
48 hours on Court TV tonight, 7/6 Central on Court TV.
Tonight on Closing Arguments, the disappearance of Sebastian Rogers, a 15-year-old boy with autism. We'll bring you the latest developments as the search for Sebastian continues.
Closing Arguments tonight at 8/7 Central, only on Court TV.
Welcome back, folks. We're going to get you back to court in the Idaho students' murders case in just a moment. But first, I want to bring in trial attorney Gabe Sepulveda-Sanchez and national trial attorney Michael Jaffer, both joining me this evening. Gentlemen, thank you so much for being with me. Michael Jaffer, I'll begin with you. The issue at hand is this survey being done by a hired gun. I'll call it a hired gun, but basically it's a company that does these types of things for trial attorneys in preparation for trial, in this case, for a change of venue motion. And the issue really here is that, you know, these surveys are done. The issue is the questions that are being asked, right? They're apparently grabbing questions from the headline. So, for instance, I'll give you an example. They're asking questions like, have you heard about the fingerprint on the sheath in this case? They're also asking, have you heard that there's cell phone evidence that places him by the house that night on 4 different occasions? As opposed to more general questions, which is what we normally see, like, what do you think about the case? Do you think he's guilty? What have you heard? Et cetera, et cetera. Michael, what do you think about what the issue at issue here, the central issue here, and whether the defense should be allowed to do what they're doing, or is the state correct?
As far as the central issue, I take a very conservative view. I have never seen a situation where a change of venue was granted and it harmed the case. I've seen many instances where a change of venue was not granted and it harmed the conviction based on appeal. This place involves a crime scene that has become a shrine in that community. I don't even know why we're even here, even arguing in terms of the court and the litigants, why they're even arguing about this. They should have agreed to change the venue for this case a long time ago. So that's for the central issue. As far as the specific issues as to whether or not they should ask those questions, absolutely. I believe they should be able to ask any. I mean, there's limits, obviously, but like, why not? How would it, like, you put us in this situation, Your Honor, by making us even argue this. Like, why even get to this position? He put a gag order. they are now debating whether or not to change the venue. Now they're debating whether or not the questions are reasonable. I think those are legitimate questions, because if we're going to convict this person, let's convict them the right way by going through the process thoroughly.
Yeah, so Gabe, I want to get your thoughts on this. You heard what Michael had to say. The question is, of course, with that gag order, with that no dissemination order telling these attorneys, hey, you know, you're not supposed to put out any more information that could prejudice this jury pool. Of course, the state is claiming these questions are doing just that.
Yeah, I agree. I think you have to take an approach as it's innocent until proven guilty. I like the approach of let's make sure this guy has a fair trial in all aspects. And just like our commentator was saying, this is a landmark case. Nothing like this has happened in that area in Idaho. Historically, there's nothing been similar to that. So you want to make sure that this is not going to get overturned on appeal. I think it's in everyone's best interest, the court, the DA, the families, to let this guy have a fair trial and let the evidence play out. I think they need to be very liberal in this motion to change venues. I'm totally okay with those types of questions being asked. This is important, you know. This is such a nationwide. This trial's had major publicity around the country. There's a good chance that the jury pool is tainted, and they might be prejudicial to the defendant. So I definitely agree. I think they should just go ahead and let this thing ride out. Be very liberal with the defendant and their motion, and let's see what happens. And
So hold on, Mike. So Gabe, we got to figure out exactly what the judge is ultimately going to do. So I want to get everyone back into court.
That is the real problem, as Mr. Thompson pointed out.
So the way it was done, I know in the other Kootenai County case, permission to do the survey wasn't sought of the state, the prosecutor, or the judge. I can comment on that one. I know about that. I don't know about the other cases. So that takes us to why did we ask the questions we asked? I don't think it's common to get permission from the state to do our work. I think that it's a surprise because it's the first time that's happened, at least when this court's been on the bench and in Mr. Thompson's tenure here. So I understand that. When I met with Bill and Ashley in their office on the 21st, I asked them not to give you the police reports that they had in the transcript without me having a chance to be heard, because I didn't want an order without us being able to talk to the court. I asked if we could maybe set up an on-the-record meeting with the court to talk about this. And that wasn't what was done. It was Friday when this went out.
Sure. I mean, I would have been available on Friday to talk about it if that was necessary.
I would have gladly sat down. I didn't offer that next Friday. I would have come to town for it. I offered the following Thursday and Friday, knowing that I had a lot of availability both of those days. I would have come to town. I would have gladly sat down. By this point, the prosecutor knows I'm not telling him my preparation in the case, and I could have explained it. The thing I didn't want to happen is exactly what did happen. All of a sudden, there's an accusation against us and there's an order signed stopping us. I appreciate the court being willing to just push everything out 2 weeks. I think that's helpful. And I mean, if that's what the court's willing to do, that's fine. But the problem is we are stopped and then we have to respond to this. And if you think about the non-dissemination order, for sure, we wanted that non-dissemination order. We're the ones that asked for it. We're the ones that argued for it. We also know that our non-dissemination order mimics Idaho Rule of Professional Conduct 3.6. And when you look at that in the comments of that, I think it's helpful. There are things that we can say publicly, but we choose not to. Our team doesn't even so much as answer no comment to emails, to calls, to people trying to talk to us, because we just don't want to do that. It's easier to say nothing. So the construct of this survey is to ask these general questions. And then you ask specific ones because you get different answers when you ask those. It is not injecting information. They are, have you read, seen, or heard? And remember, these are anonymous and these are random. So they're not planned. Nobody's planned to be contacted. I don't know the names. I'm sure I can get the phone numbers if that's what the court wants. But I don't know who the people are. Nobody's identified as the person they're being called on behalf of, even when pressed by Detective Payne, that people conducting the survey didn't know. If we go back to the non-dissemination order, which mirrors Rule 3.6, that's to prevent lawyers involved in a case from making statements that will be widely disseminated, right? To talk to the press. And the purpose of that is because I read the police reports. I would have a little more credibility than anybody else on the street saying something about the case. Same with Bill. That's the purpose of it, so that we don't say things to the press on Dateline, on 48 Hours, because we've actually read police reports, we've interviewed people, and we're doing the work on the case. So when you have an anonymous survey that doesn't identify the person conducting the survey, didn't know who was behind it as far as which party to the case, they can't answer that. So all of a sudden, their questioning about what you've seen in the media doesn't come from a particular party in the case. And the purpose of it is to...
All right, we do need to take another break, folks. More from the motion hearing in the Idaho student murders case when we come back. Keep it here on your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. We're following the latest in the Idaho student murders case. Bryan Kohberger is accused of killing 4 University of Idaho students in November of 2022. Right now, a hearing is going on regarding a possible change of venue. At issue is a request by the defense to survey the jury pool to help support their argument to move the trial out of Latah County. Let's get back inside that courtroom.
People have exposure to the case. If you look at State's Attachment B, you can see on page 2 that there's questions, and I'm at lines 10 through 12, about what they know about the case from the media. This is all, again, looking at our non-dissemination order and looking at the rule, things that are in the public record, right? That everything is public in this case unless we specifically seal it. So this person says they don't know much. And then if you go to page 4, there are several things they do know, and that's the purpose of it. When somebody's given a broad question, tell me what you know about this, they're like, I don't know. I don't really know what you want, so I'm not going to say anything. And they don't give you an answer. But when you say, have you read, seen, or heard X? Well, yeah. And then it's the next question. And if the answer's no, I don't, it's next question. Nobody's saying, well, it was in the newspaper on 15 occasions. And this is particularly borne out when you think about the things, and the state said it, some of these things are things that are just not true. That's what the Haddon case tells me I have to show you. It's not enough that there's just a lot of media coverage, and it's a lot more harmful if it's media coverage about things that aren't true. So it's nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media? And if the answer is yes, you move on. If the answer is no, you move on. That's what the survey was about. And you can see why, looking at pages 2 and 4 of State's Exhibit B. And I think that we should also think about what the words in the non-dissemination order mean. When you say we disseminated information, that means to make widely available. This is a one-on-one conversation with no party identified. This isn't making it widely available. When you talk about disseminating information, the definition of that is to put it out there by public means, radio, TV, social media. And that's not what was happening either. These were questions. And they were things lifted 100% from the media, 100% already in the public record. And it is a one-by-one conversation. This isn't something that's being put out there through social.
Well, it kind of is.
Well, now it is, but I certainly didn't expect
400
this.
people okay? It's planting some seeds where then people are encouraged, or they say, oh, wow, I didn't know that. I'm going to look more into this. I mean, again, I mean, we were trying to keep the false information that was out there in media land, that it wasn't going to affect your client.
I agree. This is less than 1% of the population. It's one-on-one. It's not by means of public communication. To think about alleging that we violated the non-dissemination order is basically alleging that we violated our ethical rules as well. And there's parts to it.
I'm not accusing you of that, especially now that I know that you that you didn't.
I didn't write the question, but I knew what was going to happen. I take responsibility for the choices on the case, Judge, but I just don't think this is a violation of the ethical rules or non-dissemination order. These are questions about things already in the public record. That's in our order. That's in the rule.
Let me ask you this. I mean, really, getting hit by this late on Friday afternoon, okay? I mean, I'm not sure what a judge should do in a situation like that, but I just say, yeah, no, keep going until we can have a hearing in 2 weeks or less than 2 weeks. Or do you just pause it down so that everybody can talk about it and figure out if there is an issue? That's how I looked at it from where I was sitting and what the information that was provided to me. And you did respond to it, but you said you were going to submit a brief and affidavit. That's great. But it was 5 o'clock on Friday.
I know.
So,
and I mean, I can't tell you how frustrating that was for me. I'd had this conversation with the prosecutor the day before. I'd offered to come and talk to the court and let the court look at all this. I knew full well if they did exactly what they did, the court would sign an order before I had a chance to say, hey, wait a minute. Let's really look at all of the words in the non-dissemination order. Let me tell you why we did this. I knew exactly what would happen. I don't want to say that there's that you should do something different. I want to be heard on these things. I don't want the court to, on a Friday night, get a flurry of things that I can't respond to and ask you to think about the bigger context. We're lawyers. Words mean something.
Well, did you think I wasn't going to give you an opportunity to be heard?
No, your order said I could be heard later, but there was a decision that was made then. And it's hard for me to wrap my head around the court taking this as an emergency motion when the words in the state's motion telling you put a stop to it are, it seems like they might have violated this. That is a weak accusation for the court to take an emergency order position on. But I know why the court did. The court has all of this and no context for it. And it's a Friday night. And I mean, if you'd received this on Thursday, my guess is you would have said, we're having a hearing Friday morning. I don't care if it's by Zoom.
Right. I told you on both sides, if you need to have a quick hearing, let me know. We can do it on Zoom. I mean, I want to move this thing along.
I would have been available.
Spending all this energy, okay,
yeah,
about this issue.
I lost a weekend of what I planned to respond to this. I thought we would probably be dealing with it in chambers on the record meeting on the Thursday or Friday until I got the motion.
Yeah, I have about 7.
So obviously the defense is angry because they're saying the judge stopped them from doing their surveys based on a late Friday night motion by the state. They don't like it. They think it violates due process of Bryan Kohberger. All right, let's squeeze in a break, folks. Here, we'll get you back into the courtroom for more arguments in the Idaho student murders case when we come back. Keep it here on your front row seat to justice.
One of the most successful true crime TV shows ever.
This is crazy.
Now has a new home on America's original true crime obsession, 48 Hours on Court TV. Coming up next on Court TV.
Tonight, on closing arguments, the disappearance of Sebastian Rogers, a 15-year-old boy with autism. We'll bring you the latest developments as the search for Sebastian continues.
Closing arguments tonight at 8/7 Central, only on Court TV.
All right, before we head back to court, I want to bring back in trial attorney Gabe Sepulveda-Sanchez and national trial attorney Michael Jafer. And Gabe, let me start with you. This issue revolving around the due process argument is an interesting one. What do you think about it? Because I can tell you this, and I think we all know this, that it was a calculated move by the state to file that motion late on a Friday. And what the defense is basically saying is, look, we have no problem with you saying there's a chance we violated your dissemination order, but we should have had arguments over it before you took the action of stopping us from doing our work.
Yeah, definitely. I agree. Definitely an unfair advantage here to have that filing on a Friday afternoon. You have no chance to oppose it. You know, you have the weekend going by there, so it's a few days of work you're doing also. So, I mean, I like, as far as the approach goes, I think they were on the right for doing this. They did a survey. It sounds to me like most of the community already is preconditioned on this case. That's why people call the police and inform the DA that some social worker or sociologist was contacting them about this case. So you can already tell there's some emotion stirred up with that decision by jurors to call the DA. But in any type of motion you're filing, for a motion for change of venue, you need evidence, and a part of gathering that evidence is getting expert declarations, getting surveys, doing these types of research projects to back up your motion with evidence. So I don't think they're doing anything wrong here. I think they're just being well prepared and being good defense lawyers. So I have nothing wrong with what they're doing, in my opinion. They're being great lawyers and good advocates for their client.
Yeah, zealous representation. Again, the burden is on the defense, Michael. Reasonable probability of prejudice to their client. What do you think a solution might be here for the judge? I certainly understand the argument that there are folks who may not know things about this case, but by asking them these questions, you're injecting that information, and they could be spurred to go look for more information. So that is an issue. What do you think a solution might be?
Every single defendant has a constitutional right for due process. And that means sometimes some uncomfortable things for the jury pool when the population, when they have prejudged a person as being guilty before the trial even begins. Due process has uncomfortable repercussions for those people in that crowd. That attorney literally called up the judge and embarrassed him on the record. She said, I feel like you and the prosecution have basically prejudged the case and you made the decision without even hearing argument. I think a solution is for the judge to just let it go forward. It's due process, buddy. That's all it is. It's due process. It's not going to be comfortable. People who've prejudged this person as having been guilty are not going to be comfortable with what due process entails. He might end up being guilty, but due process has to be adhered to.
Fair enough. I like that answer. All right, Mike, stand by, guys. I do want to take folks back into that courtroom for more of the arguments.
Well, you can see we lost a lot of time.
I'm not complaining about it because I'm learning a lot.
The last thing I'm going to say on this, Judge, is that non-dissemination order contemplates that you make this statement that you reasonably know is going to go out and harm the trial. This survey was never intended to do anything but identify issues within this county to support or defeat our argument for venue change. When you hear from Brian Edelman, which I don't know if you have to now because I've said most of the things.
I'm happy to hear what he has to say if you want things to be said. You
would know, and you probably know from his affidavit, sometimes he recommends against venue change.
Sure.
Because it's not there. He's done with Latah County. The results aren't compiled yet. I anticipate he'll recommend we change venue. Where we are now is we'd like to finish the other two counties. You don't have to do two.
Well, you did say that he said that Latah County is biased.
I anticipate he's going to recommend we change venue for that reason.
I'm interested from him how he defines bias. We all have some biases.
I will not put words in his mouth for that one.
I'm not expecting you to do that.
I will either have him testify today if you want to hear it today, or we'll do it at the venue change hearing when we get there. The question, I understand the court's willing to set our deadlines out 2 more weeks for venue issues. The question remains then, what do I need to show you? What do I need to present to you so that we can do a survey, a comparative survey? The target is 2 additional counties, and I really hate that I'm in here telling you all what we need to do, but here we are. So what we need to do is survey 2 additional counties. And I mean, we don't have to, we can come in with what we have, but generally I think courts ask, where could we go? And I think that's a fair question here, because we do know the media coverage has been extensive. And so I think it's fair to understand if there's a difference. If there's not, then you're left for
Are you going to tell me what counties?
I mean, I can. Do you want me to publicly disseminate that? Because this is the very definition of public dissemination.
I don't know if that should be done, or it seems like it could have some, whether or not there's some credibility about the survey, depending on what county you are looking at. We have very different counties and different thinking throughout the state. So I don't know what Mr. Edelman has in mind, or what you have in mind.
I can tell you, Your Honor, his recommendation is that we do one of the counties in Southeast Idaho because it's a different news feed and it's not on the front page of the paper every day. So we will do a Southeastern Idaho county. That would either be Bannock or Bonneville, and I think Bonneville is slightly bigger than Bannock. The other county is Ada, and the reason for Ada is because it has a very large courthouse with a lot of good security in it. That court system has handled high-profile cases in a way that's safe for everybody. The population's very large there, so even if we had to draw off a lot of jurors, we'd have the population there to do it. Additionally, Ada County makes sense when you look at the Rule 21B, the convenience because of the airport and the number of out-of-town people that will be coming in, and the ability to have hotels and restaurants where there would be people wouldn't be running to other people necessarily. So Ada makes a lot of sense for a lot of reasons to me. Those reasons, the courthouse security and places to stay among them. But Mr. Edelman, Dr. Edelman has told us that because of the news feed that we really need to do a Southeastern Idaho community. And so the decision was to do both. And in my mind, that is because it makes sense to know if we're going to go to the time to understand this and really give the court a picture, the court might want to know those 2 questions.
Thank you.
Sure. I don't think I have anything left to say right now.
Okay, thank you. All right, Mr. Thompson or Mr. Nye?
I'm not sure that the due process issue is something that's at issue right now.
I think I've already made it. This decision. I mean, based on the facts and the law. I mean,
There's no due process violation here.
No.
There is nothing wrong. In fact, law contemplates the court can take emergency action to stop something and call a timeout until it affords everybody the opportunity to have their say.
All right, so there's no due process violation, and the judge ends up taking the other issue under advisement as far as the type of questions that can be asked on that survey.